does the human rights law of New York City and New York State apply to protect non-residents of New York City and New York State? To find out, you have to read Said versus Bloomberg LP, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Said versus Bloomberg LP. The citation for this case is 2024 New York Slip Opinion 01330, published by the New York Court of Appeals on March 14th of 2024. The issue in this case is whether New York's human rights law for both the state and the city apply to non-residents who are not yet employed in the city or state of New York, but who seek a city or state job here in New York. To understand and appreciate the context of this case, I think it's helpful to know that the New York human rights law, which is found for the state, it's Executive Law 296, and for the city, it's Administrative Code 8-107. They basically say that every individual within the state has an equal opportunity to enjoy a full and productive life, and that a failure to provide that opportunity because on the basis of discrimination, prejudice, or intolerance is unlawful. So if an employer discriminates on the basis of race, gender, and certain other protected statuses, that would be unlawful, and they are potentially liable for a lawsuit under those two different sections of law. The facts in this case are the plaintiff is Said, who is a female South Asian in ethnicity person. And in 2014, Said started working for Bloomberg Media, which is a news organization with a global headquarters located in New York City. The plaintiff was a reporter based out of Washington, D.C., the Washington, D.C. Bureau. In 2018, Said applied for various positions in New York City, including as the Economy Forum editor position and the UN reporter position in New York City. She inquired multiple times about it. The UN job was ultimately given by a man who had allegedly less practical experience and less formal education than Said did. Her managing editor told her that Bloomberg said the job was not being converted to, quote unquote, a diversity slot. She claims that constituted constructive discharge, that they weren't going to really promote her within the organization. And so she left her job in 2018, and she then moved to California. She then sued Bloomberg, the defendant here, under state and city human rights law, under that administrative code and to the executive law. She claimed the defendant discriminated against her on the basis of her race and her gender by denying her the promotion that she sought. The defendant, Bloomberg, moved to dismiss the case. First they transferred it to federal court, and then they moved to dismiss the case. The Southern District granted the application to dismiss, saying the plaintiff could not show that the defendant's conduct impacted her in New York City or New York State, and she didn't live in New York City or New York State. She lived either in California or Washington, D.C. And human rights law had a prior case named Hoffman, and the Southern District read that case to say that the human rights law is limited to people who live or work in New York City. The Second Circuit, on appeal, the Second Circuit reversed that decision and said that it would apply to her. It then goes to the Court of Appeals, and they certify the questions to the Court of Appeals. It goes to the they then appealed it, and it goes to the Court of Appeals in the Second Circuit, and they ask whether a non-resident, not yet employed in New York City or New York State can satisfy the impact requirements of the human rights laws. And the holding here from the New York Court of Appeals is that the intent of the statute is to maximize the deterrence of discriminatory conduct. And because that's the intent in the statute, the courts must liberally construe those human rights laws broadly in favor of the discriminated against, allegedly, plaintiffs to the extent possible. There's two ways that a non-resident can satisfy the impact requirements of the law. First is if they work in New York, and second is if they can establish that the challenged conduct, the discriminatory conduct, had some impact on the plaintiff within the New York geographic boundaries. And in this case, the plaintiff here wanted to start working in New York, so she was a non-resident working affirmatively by her conduct to get a job in New York City, and the legislature did not intend to give, this is what the holding is, the legislature did not intend to give employers the ability to discriminate against non-residents. It should also prohibit discrimination against non-residents trying to work here. So they answer the certified question saying, yes, non-residents who seek to work in New York City or New York State can utilize the human rights law to accomplish the goal, which is to prevent discriminatory conduct on the basis of race, gender, and other protected classes. And that's the case of Saeed versus Bloomberg LP. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.